Supreme Court Justice Samuel Alito wrote in a leaked draft of the majority opinion on Dobbs v. Jackson Women's Health Organization, far from bringing about a national settlement, Roe and Casey have inflamed debate and deepened division. You could call that the understatement of the century. He added, Roe was egregiously wrong from the start. Its reasoning was exceptionally weak. Then came the words that shook a nation. We hold that Roe and Casey must be overruled. The 14th Amendment provided the legal basis for both cases, but from a legal perspective, why would Alito argue that basis was weak? And what might an overrule of Roe and Planned Parenthood v. Casey in 1992 mean for other cases, like Obergefell v. Hodges, which protects same-sex marriage?
My name is Ilya Somin. I'm a law professor at George Mason University. From 1973 to the present, there has been extensive criticism of Roe versus Wade on various grounds. I'll just mention two, both of which figure in the recent draft opinion. One is the argument that at least up until 1973, there was no history of this being a right protected by the 14th Amendment. And certainly no one or almost no one in 1868, when the amendment was enacted, thought that a right to abortion would be protected.
The 14th Amendment came just 2 years after the 13th, which abolished slavery. The ratification of the 14th on July 9, 1868 was one of the conditions for the states that had seceded to regain representation in Congress.
The second criticism that is offered is that it's a mistake to analogize abortion to something like contraception, or later to the Supreme Court's decision striking down laws banning same-sex sexual relations, because with contraception, with same-sex sexual relations, with sending your kids to private school and so on, there's no great harm to or possible harm to innocent people that results from this.
Whether terminating a pregnancy indeed or possibly harms innocent people is a question we won't try to answer. But we can dig further into the 14th Amendment, on which Roe v. Wade and several other critical Supreme Court cases like Obergefell and Brown v. Board of Education, which ended separate but equal segregation in public schools, are based.
To make a long story short, it was enacted in 1868 in the aftermath of the Civil War, and its main purpose was to provide at least some degree of equal rights for African Americans, perhaps for other minorities, to prevent southern states and also some states elsewhere from continuing to repress and discriminate against them. There are several different clauses in the 14th Amendment. Probably the ones that are the most significant for our purposes are the Due Process Clause, which says that states are not allowed to deprive people of life, liberty, or property without due process of law. The Due Process Clause is historically interpreted as not only saying that people are entitled to procedural protections before the government can take away their life, liberty, or property, but also that they're entitled to at least some substantive protections, including, of course, under Roe versus Wade, abortion. Then there is the Privileges or Immunities Clause, which says states are not allowed to take away the privileges or immunities of citizens of the United States. The Privileges or Immunities Clause has been largely read out of the Constitution by the Supreme Court, but there's been some movement in recent years to try to bring it back. And back in 1868, at the time the amendment was enacted, many people thought that that would be the most important part of it. And finally, there is the Equal Protection Clause, which prevents states from denying the equal protection of the laws. This latter clause is usually interpreted as forbidding or at least severely limiting discrimination based on race or ethnicity, and also such other characteristics as sex or religion. There's some other provisions of the 14th Amendment as well, but those are the biggest ones, and in combination, over many decades, they've been used to protect such important rights as rights against racial and ethnic discrimination, many types of personal liberties, same-sex marriage, contraception, many others as well. In earlier periods, also some economic rights, though the Supreme Court is in more recent decades severely limited their protection and almost read them out of the amendment.
Yeah, we'll do a whole nother video on those economic rights, and you can help that video happen by liking, subscribing, and hitting that bell button. But for now, the question is, how did the 14th Amendment become the cornerstone for abortion rights, not to mention many others?
Over time, the Due Process Clause of the 14th Amendment has been used to protect not just procedural rights, but also substantive ones. And there's a long history of various substantive rights being protected. For example, in the 1920s, the Supreme Court issued two important decisions which said that the government can't forbid parents from having their kids take foreign language classes, and also that it can't forbid them from enrolling their kids in private schools as opposed to public ones. Later in the 1960s, in a case called Griswold, the Supreme Court ruled that the government cannot forbid the sale and distribution of contraception because part of the liberty protected by the 14th Amendment is a liberty to engage in private procreative or sexual activity. Originally, that decision was limited to marital contracts, that the government cannot forbid married people from accessing and using contraception, but it was later expanded to single people as well. Probably the most controversial of these types of so-called substantive due process decisions, that is, decisions that protect substantive rights under the Due Process Clause and not just procedural ones, is Roe versus Wade, decided in 1973, which ruled that at least up to a certain point in the second trimester, there is a right to abortion, which the government cannot restrict more than minimally. The Supreme Court majority reasoned that this can be justified on a basis similar to the right to contraception because it is a private sexual or reproductive activity.
Due process is such a fundamentally important right that it actually appears in both the 5th and 14th Amendments. In the 5th, it reads, "No person shall be deprived of life, liberty, or property without due process of law." In the 14th, it says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." But the 14th Amendment in general, and the Due Process Clause specifically, might not have been the strongest legal basis for abortion rights.
It's a tough argument to make because for two reasons. One is it's very hard to argue the right to abortion is in the text or the original meaning of the amendment or in long-standing tradition or precedent before Roe versus Wade. The second is that unlike with many other rights that have been protected under the Due Process Clause, here there's a very plausible argument that the right in question leads to grave harm to innocent people, perhaps even harm equivalent to murder. That's not my view. I do not believe abortion is murder, but I think it's a plausible, serious argument in a way that you would sound silly if you made the same argument about contraception or same-sex marriage or any number of other rights that have been protected using the Due Process Clause.
What that means is, well, we sure haven't heard the last of the debate. Even if the court does overturn Roe v. Wade, similar cases are sure to arrive on the court's docket, potentially with different or stickier legal backing. But there is reason to be optimistic that same-sex marriage is safely entrenched, thanks to, let's call it, two-factor authentication.
I think as a matter of legal precedent and legal reasoning, Roe is indeed weaker than Obergefell. So Obergefell, which is, for those who do not know, Obergefell is the Supreme Court's 2015 decision striking down state laws banning same-sex marriage. Obergefell has this twin basis. It isn't just based on a due process clause, it's based on the Equal Protection Clause. I mentioned before that the 14th Amendment has a due process clause, but it also has an equal protection clause, which restricts invidious discrimination. And in Obergefell, the Supreme Court, in a 5-4 decision, did not rely solely on the due process clause. They relied on the due process clause in combination with the Equal Protection Clause. And under the Equal Protection Clause, there is a very strong argument that laws banning same-sex marriage discriminate on the basis of sex, because who you can marry under a law like that depends on your sex. If you're a man, you're not allowed to marry other men, whereas if you're a woman, you can marry a man under that framework. And therefore, I think it's very unlikely that even the Supreme Court overrules Roe, that they would go on to overrule Obergefell. There's also sort of a hard political or sociological fact that Obergefell now enjoys overwhelming public support. Opposition to same-sex marriage, which used to be quite strong in much of the United States, has greatly diminished today. Even in conservative areas, most people support same-sex marriage or accept it.
If or when abortion rights return to the Supreme Court, what might be a stronger legal basis for them?
Best argument probably is one that's somewhat similar to the one that the Supreme Court used, although it would more explicitly rely on liberty rather than privacy, because privacy is sort of a nebulous concept. The Supreme Court could say, and to some extent it did say in Roe, that this is analogous to other decisions protecting people's rights to intimate relations, such as with respect to contraception, later also with respect to same-sex marriage. There's another possible rationale for Roe versus Wade, which some people have argued for, though it has never found much favor with the Supreme Court, and that is the idea that laws restricting abortion are a form of sex discrimination because only women can get pregnant. Therefore, only women are restricted by those laws. I think the problem here is that this doesn't really classify on the basis of sex. It classifies based on pregnancy, but the fact that only people of one sex can be pregnant, I don't think by itself turns it into a sex classification. And obviously, when you have laws restricting abortion, it is not only women who can be punished or restricted. Obviously, doctors or nurses or other staff performing abortions, many of them are male, and they are often punished under these laws. The men who participated in the formation of the pregnancy, they can be harmed, or they can suffer from abortion not being an option, because of course if the baby's carried to term, they may have obligations to support the child. So I think the sex discrimination argument, while it's a very clever legal theory, I don't think it's that good an argument, but there are definitely people who do think that. Justice Blackmun, the Supreme Court justice who wrote Roe versus Wade, near the end of his life in the 1990s, he wrote a concurring opinion saying maybe the sex discrimination argument is a better theory than the one that he himself embraced when he wrote Roe. But there has never been a majority on the Supreme Court for that view. I'm pretty confident there isn't one now. And I think, it's not an easy argument to make.
So that's the 14th Amendment in a nutshell. Put on your best lawyer hat and let us know in the comments. Is it a strong legal basis for such a divisive issue? How would you defend or attack it? Keep it civil, of course.